The 43rd session of the Senate in the third regular session of the 16th Congress is hereby called to order. May I ask our colleagues to rise for a minute of silent prayer? Thank you. With the permission of the chamber, the chair declares a 1-minute recess. Sina? Sani? Pakai ano nyo? Ha? Ha? Ilan na? Kulang pa rin. Pinasundo naman sa pages. One more. Sunny Trillanes for... Si Santos Benyo na ba? Ha? Isang sponsorship pa. Session is resumed. The Majority Leader, the Secretary will call the roll.
Roll call of members. Honorable Senators Angara, Aquino, Binay, Cayetano Alan Peter Compañero S., Cayetano Pia S., Defensor Santiago, Ejercito, Enrile, Escudero, Estrada, Gingona, Unasan, Lapid, Legarda, Marcos, Usmeña, Pimentel, Po, Rector, Revilla, Soto, Trillanes, Villar. Senate President Drilon.
13 senators are present. The chair declares the presence of a quorum. The Majority Leader is recognized.
Just acting again, Mr. President.
Okay, acting Majority Leader.
Mr. President, I move that we dispense with the reading of the Journal of the 42nd Session, December 8, 2015, and consider the same as approved.
Any objection? Hearing none, the reading of the Journal of Tuesday, December 8, 2015 is hereby dispensed with and the same is hereby approved.
Mr. President, I move that we proceed with the reference of business.
The Secretary will read the reference of business.
Message from the House of Representatives. Letter from the House of Representatives informing the Senate that on 9 October 2015 it passed the following House bills. House number 6193 entitled An Act Renewing for Another 25 Years the franchise granted to Kalayaan Broadcasting System Incorporated under Republic Act number 7303 as amended by Republic Act number 8105 entitled An Act Granting the Kalayaan Broadcasting System Incorporated a franchise to construct, install, operate, and maintain radio broadcasting stations in the island of Mindanao and for other purposes. And House number 5570 entitled An Act Renewing for Another 25 Years the franchise granted to Baan Electric Corporation, formerly Baan Electric and Engineering Corporation, to construct, operate, and maintain an electric light, heat, and power system in the municipality of Baan, province of Batangas, under Republic Act number 7578, in which it requests the concurrence of the Senate.
Public Services.
Bills on first reading. Senate number 3028, an act declaring the month of April every year as Childhood Cancer Awareness Month and for other purposes by Senator Maria Lourdes Nancy S. Binay.
Health and Demography, Women, Children, Family Relations, and Gender Equality.
Senate number 3029, an act separating the city of San Pedro from the first legislative district of the province of Laguna to constitute the lone legislative district of the city of San Pedro by Senator Pimentel III.
Rules.
Senate number 3030, an act strengthening the prohibition against labor-only contracting, amending for this purpose Presidential Decree number 442, otherwise known as the Labor Code of the Philippines, as amended by Senator Pimentel III.
Labor, Employment, Human Resources Development.
Communications, letters from the Office of the President of the Philippines transmitting to the Senate two regional copies of the following. Republic Act number 10706, entitled An Act Protecting Seafarers against ambulance chasing and imposition of excessive fees and providing penalties therefore, and Republic Act number 10707, entitled An Act Amending Presidential Decree number 968, otherwise known as the Probation Law of 1976 amended, which were signed by His Excellency President Benigno S. Aquino III.
To the archives.
Letters from the Bangko Sentral ng Pilipinas transmitting to the Senate copies of the following certified and authenticated BSP issuances in compliance with Section 15A of Republic Act Number 7653, the New Central Bank Act, Circular Letters Number 2015-058, 67, 68, 9, 70, 71, and 72, dated 22 September, 4, 5, 12, and 13 November 2015, Circular Numbers 891, 892, and 893, dated 9 and 16 November 2015, Memorandum Numbers M 2015-39, 40, and 41, dated 4, 5, and 27 November 2015.
Committee on Banks.
Committee report number 335, submitted by the Committee on Economic Affairs on Senate number 2779, introduced by Senator Sani Angara, entitled an act declaring the second week of November of every year as Economic and Financial Literacy Week, recommending its approval without amendments, taking into consideration House number 5452. Sponsor, Senator Joseph Victor Ejercito.
Calendar for ordinary business. With the permission of the Chamber, we declare a 1-minute suspension. Bong, bong. With the permission of the Chamber. Session is resumed. The Majority Leader, Acting Majority Leader is recognized.
Mr. President, we have some guests in the gallery from the LGU of Local Government Unit of Bagao, Cagayan. We have SB member Virginia Loretta Herrero, ABC Barangay Captain Anita Calderon, ABC Treasurer, the Federation of Persons with Disabilities Benjamin Miguel, who is the head, Mario Bulusan, President, and Mrs. Lourdes Lazaro, the delegation head. We also have members of the National Liberation Front Southern Philippines, headed by Sultan Sharif Abubakar and General Raimundo Bulos, and members of the Kalipunan ng Liping Pilipina, Samal Bataan Chapter, headed by Julieta Oconer. I move that they be recognized, Mr. President.
We welcome our guests to the Senate and make their presence of record in this afternoon session.
Mr. President, with the consent of the Senate, I move that we resume consideration of Senate Bill 3004 under Committee Report 292. This bill pertains to the proposed right-of-way for national government infrastructure projects.
Any objection hearing none, consideration of the measure is in order.
Mr. President, the parliamentary status is that the sponsor delivered his sponsorship speech last December 7. I move that we open the period of interpellations.
The period for interpellation is in order. Senator Marcos is recognized, the principal sponsor.
Thank you, Mr. President. I believe that there are no reservations by any of the members to interpolate on this measure.
I move that we close the period of interpellations, Mr.
So
President.
closed.
I move that we open the period of committee amendments. Mr.
Committee
President.
amendments are in order.
Thank you, Mr. President. Upon the suggestion of the chair in the December 7 session, we went back to examine and have a look at the version of the House on the same subject. to see if there were substantial differences between the approved version from the House and that was filed here in the Senate. And as we mentioned in during that session, there are no substantial differences. There are differences perhaps on style and language, but none that could make that are a material difference in terms of the implementation and the concept behind it. So, Mr. President, as a committee amendment, we would like to adopt the House version of that bill, House Bill number 5588, an act facilitating the acquisition of right-of-way site or location for national government infrastructure projects. That is the title, Mr. President.
Okay. Any objection? Hearing none, so adopted as a committee amendment, the House version. Majority Leader?
I move that we close the period of committee amendments, Mr.
So
President.
closed.
I move that we open the period of individual amendments.
Individual amendments are in order.
There are no members who wish to propose individual amendments. I move that we close the period of individual amendments.
So closed.
Mr. President, I move that we approve on second reading Senate Bill 3004 under Committee Report 292. I so move.
Any objection? Senate Bill 3004 under Committee Report 292 is hereby approved on second reading.
Mr. President, with the consent of the Senate, I move that we resume consideration of Senate Bill number 12 under Committee Report number 31. This is the bill on barangay workers' benefits, Mr. President.
In order.
Mr. President, parliamentary status is that the period of committee amendments on the bill had been terminated last December 7. I move that we open the period of individual amendments.
The period for individual amendments is in order.
I move that we recognize the sponsor, once again, Senator Marcos.
Senator Marcos is recognized.
Thank you, Mr. President. I am informed that there are no reservations as to proposed individual amendments on that measure, Mr. President.
Mr. President, in that case, I move that we close the period of individual amendments.
So closed.
Mr. President, I move that we approve on second reading Senate Bill number 12 under Committee Report number 31.
Any objection? Hearing none. Senate Bill number 12 under Committee Report 31 is approved on second reading.
Move that we suspend consideration of the measure, Mr. President.
So suspended.
Mr. President, with the consent of the Senate, I move that we resume consideration of Senate Bill number 2968 under Committee Report 264. This is the bill on customs modernization and tariff, Mr. President.
Any objection? Hearing none. In order.
Mr. President, the parliamentary status of the measure is that we are still in the period of individual amendments. I move for recognition as the sponsor.
The acting majority leader as the principal sponsor is recognized.
I move that we recognize Senator Bamakino for proposed individual amendments.
Senator Bamakino is recognized for the period of individual amendments.
Thank you, Mr. President, and thank you to our good sponsor, who's also the acting majority floor leader today. Mr. President, I have a number of amendments. On page 75, line 5, delete the sentence, "For this purpose, to ensure consistency and harmony in the formulation and implementation of customs policies affecting the free zone, the Commissioner shall sit as an ex officio member of the Board of Directors of all free zone authorities." The section shall now read as follows. Section 817, coordination with free zone authority. To ensure compliance with customs laws and regulations, the Bureau shall coordinate with the governing authority of the zone. I so move, Mr. President.
Any objection? Hearing none. Approved.
We accept it, Mr. President. We accept the amendment.
Mr. President, secondly, on page 83, line 12, delete the phrase, "provided that no abatement or refund of duties, taxes, and other charges shall be allowed on goods lost or destroyed in bonded public or private warehouses outside the customs zone." The section shall now read as follows. Section 911, investigation required in case of abatements and refunds. The customs officer concerned shall, in all cases of abatement or refund of duties, submit an examination report as to any fact discovered which indicates any discrepancy and cause the corresponding adjustment on the goods declaration.
I accept, Mr. President.
Any objection? Hearing none. Approved.
Mr. Sponsor, on page 145, line 29, delete the words tariff problems and replace it with tariff and trade-related matters.
We accept, Mr. President.
Approved.
On page 146, line 14, delete the word exercise and replace it with the word have.
We accept, Mr. President.
On page 146, line 14, before the word functions, insert the word following.
We accept, Mr. President.
Approved.
On page 146, line 14, delete the phrase to investigate the following.
We accept, Mr. President.
The sentence shall now read as follows: the Commission shall have the following functions, colon. On page 146, delete lines 15 to 27 until the next page, 147, delete lines 1 to 40, and replace it with the following. Letter A, adjudicate cases on the application of trade remedies against imports pursuant to Section 710, 711, and 712 of this Act, semicolon. B, study the impact of tariff policies and programs on national competitiveness and consumer welfare in line with the economic objectives of the government, semicolon. C, administer the Philippine tariff schedules and tariff nomenclatures, semicolon. D, issue advance rulings on tariff classification of imported goods and render rulings on disputes over tariff classification of goods pursuant to Section 1100 of this Act, semicolon. E, provide the President and Congress with independent analysis, information and technical support on matters related to tariff and non-tariff measures affecting Philippine industries and exports for policy guidance, semicolon. F, analyze the nature and composition, and the classification of goods according to tariff commodity classification and heading number for customs and other related purposes, which information shall be furnished to the NEDA, Department of Trade and Industry, in parenthesis DTI, DA, DOF, DENR, and BSP, semicolon. And G, review, sorry, can we delete the end? Semicolon. G, review the trade agreements for negotiation and trade agreements entered into by the Philippines and make recommendations, if necessary, on the consistency of the terms of the agreements with the national policy objectives, semicolon. And letter H, conduct public consultations and public hearings pursuant to its functions, period.
We accept, Mr. President.
Any objection? None. Approved.
Mr. President, just for the record, I made a mistake earlier. We shall delete lines 15 to 27 on page 146 and lines 1 to 10 on page 147. I said 40 earlier, Mr. President.
You said earlier what?
40. So we just, it's delete lines 1 to 10 on page 147.
All right. Let the records be so corrected. That was an error, typographical error.
That's all for my individual amendments, Mr. President.
All right. Majority Leader and the sponsor of the measure.
Mr. President, I believe Senator Santiago wishes to propose some amendments also, but since she has asked the hardworking chairman of the Committee on Trade to propose these amendments for her, if he may be recognized.
All right. The chair of the Committee on Trade, Senator Bam Aquino, is recognized to propose the amendments of Senator Miriam Defensor Santiago. Please proceed.
Thank you, Mr. President. Firstly, on the definition of articles, on page 3, between lines 6 and 7, after section 102E, insert a new subparagraph as section 102F on articles to read as follows. Section 102, definition of terms, letter F, articles, when used with reference to importation or exportation, includes goods, wares and merchandise, and in general, anything that may be made the subject of importation or exportation.
Accept, Mr. President.
Any objection or none?
Mr. President, I also move to renumber the succeeding sections accordingly.
Accept, Mr. President.
Mr. President, the rationale for this is that this will provide greater clarity to the term articles as used in the Act. Second amendment, Mr. President, on the definition of international freight forwarder. On page 6, between lines 13 and 14, after section 102AA, insert a new subparagraph as section 102G on articles to read as follows. Still on section 102, definition of terms, international freight forwarder refers to persons responsible for the assembly and consolidation of shipments into single lot and assuming in most cases the full responsibility for the international transport of such shipment from point of receipt to the point of destination.
We accept, Mr. President.
And then we move to renumber the succeeding sections accordingly, Mr. President.
We accept.
The rationale here, Mr. President, is that the term freight forwarders, as defined in subparagraph AA, limits its definition to a local entity that acts as a cargo intermediary and facilitates transport of goods on behalf of its client. The above definition, adopted from ICC Guide for Import-Export Basics, will provide greater clarity for the term international freight forwarder. Third amendment, Mr. President, on the effective date of rate of import duty. On page 10, in line 6 on section 105, amend the provision to read as follows. Section 105, effective date of rate of import duty. Imported goods shall be subject to the import duty rates under the applicable tariff heading that are effective at the date of entry or upon withdrawal from the warehouse for consumption. So move, Mr. President.
We regret we cannot accept the said amendment. We recognize the intent is to provide greater clarity, Mr. President, but because the CMTA and the revised Kyoto Protocol provide for systems of advanced lodgement. So even if the goods are not yet entered in the country, they're already considered imported by virtue of the filing of the advanced lodgement. So that's the only reason, Mr. President, we cannot accept, because it would be inconsistent.
Thank you,
Place
Mr.
it on the
President. We
record.
withdraw that last amendment.
Thank you. Thank you, gentleman from Tarlac.
Next amendment, Mr. President, on the maximum value of goods of commercial nature, which may be cleared through the informal entry process. On page 28, in line 26, on section 402, goods declaration for consumption, amend paragraph A of the provision to read as follows. Goods of a commercial nature with free on-board FOB or free carrier FCA at value of less than 50,000 pesos. Every 3 years after the effectivity of this act, the Secretary of Finance, upon recommendation of the Commissioner, shall review and adjust this amount as provided herein to its present value using the Consumer Price Index as published by the Philippine Statistics Authority, period.
We accept, Mr. President.
Objection.
The rationale here, Mr. President, is that this adjusts the maximum value of goods. We adjust it based on the impact of inflation, and the above clause also appears in section 423 and 800, which determines the de minimis value of goods which do not require payment of duties and taxes upon importation. Fifth amendment, Mr. President, on the liability of importer for duties and taxes. On page 29, line 27, section 405, amend the provision to read as follows. Section 405, liability of importer for duties and taxes. Unless relieved by laws or regulations, comma, the liability for duties, taxes, fees, and other charges attached to importation constitutes a personal debt due and demandable against the importer in favor of the government and shall be discharged only upon payment of duties, taxes, fees, and other charges. It also constitutes a lien on the important goods which may be enforced while such goods are under customs custody.
We accept, Mr. President.
Thank you, Mr. President. Sixth, Mr. President, on the contents of goods declaration on page 31, between line 7 and 18 on section 411, amend the provision to read as follows. Section 411, contents of goods declaration. Goods declaration shall contain the names of the consignee, importing vessel or aircraft, port of departure, port of destination, and date of arrival, the number and marks of packages or the quantity, if in bulk, the nature and correct commodity description of the goods contained therein, its value as set forth in a proper invoice, and such other information as may be required by rules and regulations. Where the declarant does not have all the information required to make the goods declaration, a provisional or incomplete goods declaration shall, for certain cases and for reasons deemed valid by customs, be allowed to be lodged, provided that it contains the particulars deemed necessary by the customs for the acceptance of the entry filed and that the declarant undertakes to complete it within 45 days from the filing of the provisional goods declaration in accordance with Section 403 of this Act, Mr. President.
We accept, Mr. President.
Next, Mr. President, on page 35, line 15, Section 419, amend the third paragraph of the provision to read as follows. Section 419, examination of goods. As a general rule, the Bureau may examine the goods in the presence of the declarant or an authorized representative. Examination of the goods in the absence of the declarant or authorized representative may be allowed in exceptional circumstances and for valid and justifiable grounds, as may be defined by regulations promulgated by the Secretary of Finance upon recommendation of the Commissioner, period.
We accept, Mr. President.
Approved.
Next, Mr. President, on customs expenses constituting charges on goods, page 36, lines 23 to 26, on Section 422, amend the provision to read as follows. Section 422, customs expenses constituting charges on goods. The cost of examination shall be for the account of the importer or exporter, subject to proper accounting and documentation, period. All expenses incurred by the Bureau for the handling or storage of goods and other necessary operations shall be chargeable against the goods and shall constitute a lien thereon.
We accept, Mr. President.
Can the kind sponsor read into the record the rationale for these amendments, just for future reference?
Yes, Mr. President. The rationale here is that considering that importers or exporters shall bear expenses concerning examination of goods, for such costs to either constitute a tax-deductible expense or loss, the same should be substantiated to the satisfaction of tax authorities. That is covered by sufficient accountable forms or proof of expense or loss, Mr. President.
Approved.
Next, Mr. President, on goods entered for immediate re-exportation. On page 44, in line 13 to 19, section 605, amend the second and third paragraphs of the provision to read as follows. Section 605, goods entered for immediate re-exportation, unless it shall appear by the bill of lading, airway bill, invoice, manifest, or other satisfactory evidence that goods arriving in the Philippines are destined for transshipment, no exportation thereof will be permitted except under entry for immediate re-exportation under sufficient security in an amount equal to the ascertained duties, taxes, and other charges. Upon the re-exportation of the goods and the production of proof of landing beyond the limits of the Philippines, the security shall be released.
We accept, Mr. President.
Mr. President, we're just inserting the term airway bill, considering that the said term is defined separately from bill of lading.
Approved.
Next, Mr. President, on conditionally free importation of goods exported from the Philippines for repair, processing, or reconditioning. On page 68, line 14, paragraph X of section 800, amend the provision to insert the word substantially and thereby read as follows. Section 800, conditionally free importation. Goods exported from the Philippines for repair, processing, or reconditioning without having been substantially advanced in value and subsequently re-imported in its original form and in the same state, provided that in case the re-imported goods advanced in value, whether or not in their original state, the value added shall be subject to the application duty rate of the tariff heading of the re-imported goods.
We accept, Mr. President.
The rationale here, Mr. President, is that in practice, any item repaired, processed, or reconditioned naturally advances in value, whether perceived or actual. However, for purposes of this provision, a negligible advance in value may be deemed immaterial.
Approved.
Our next amendment, Mr. President, on establishment of bonded manufacturing warehouses. Page 70, between lines 15 and 16, section 801, insert the following as penultimate and final paragraphs of the provision to read as follows. Section 801, establishment and supervision of customs bonded warehouses. For articles manufactured in whole or in part of imported materials and intended for exportation without being charged with duties and taxes, they may be made and manufactured in bonded manufacturing warehouses under such rules and regulations as the Commissioner of Customs, with approval of the Secretary of Finance, shall prescribe, provided that the manufacturer of such articles shall first file satisfactory security for the faithful observance of all laws, rules, and regulations applicable thereto. Provided also that manufacturing warehouses in free-port zones shall be governed by provisions of the succeeding chapter. Pursuant to Section 403 of this Act, application for the establishment of bonded warehouse must be made in writing and filed with the collector, describing the premises, the location, and capacity of the same, and the purpose for which the building is to be used. Upon receipt of such application, the collector shall cause an examination of the premises with reference particularly to its location, construction, and means provided for the safekeeping of articles, and if found satisfactory, he may authorize its establishment and accept a bond for its operation and maintenance. The operator of such bonded warehouse shall pay an annual supervision fee in an amount to be fixed by the Commissioner. The bonded warehouse officers and other employees thereof shall be regular employees who shall be appointed in accordance with the Civil Service Law, rules, and regulations.
We accept, Mr. President.
Any objection?
Mr. President, on legal responsibility over safekeeping of goods stored in CBWs or CFWs. On page 72, line 2, section 806, insert the proviso on the government not assuming legal responsibility over safekeeping of goods stored in CBWs or CFWs, thus amending the provision to read as follows. Section 806, Customs Control over CBWs and CFWs. The Bureau shall, for customs purposes, exercise control over, direct and manage CBWs and CFWs pursuant to Section 302 and likewise over the goods threat pursuant to Section 301 of this Act, provided that the government shall not assume legal responsibility over the safekeeping of goods stored in any CBW, CFW yard, or premises.
We accept, Mr. President.
Any objection?
Next, Mr. President, on page 73, lines 13 and 14, section 811, amend paragraph 1 of the provision to read as follows. Section 811, period of storage in CBWs. Goods entered for warehousing may remain in a CBW for a maximum period of 1 year from the time of its arrival thereat. For perishable goods, the storage period shall be 3 months from the date of arrival, extendable for valid reasons and upon written request to another 3 months. Goods not withdrawn after the expiration of the prescribed period shall be deemed as abandoned as provided under Section 1129 of this Act.
We accept, Mr. President.
Mr. President, the rationale here is that abandoned goods are deemed as government property disposed in accordance with customs rules, specifically Section 1029 of the TCCP or Section 1130 of the CMTA. However, if not disposed, an impliedly abandoned good may be reclaimed by the owner or importer within the prescribed period, provided all legal requirements and corresponding payment of duties, taxes, charges, and incurred expenses are complied with. Goods not withdrawn from CBWs after the expiration of the prescribed period qualify as impliedly abandoned, which may still be reclaimed by the owner or importer, subject to conditions specified under customs laws. May I ask for a 1-minute suspension, Mr. President?
Suspended for 1 minute.
Ready to resume.
Session is resumed.
Mr. President, unfortunately I mispronounced a word earlier.
Yeah,
I said
thereat.
threat. It's thereat, no?
Thereat, yes.
If that may be corrected in the records.
Yes.
Yes.
I noticed that.
I noticed it too, Mr. President, belatedly. If I may continue, Mr. President.
Please proceed.
Okay. Mr. President, on claims for refund, on page 84, line 2, on section 913, claims for refund, amend paragraph 1 of the provision to read as follows. Section 913, claims for refund. All claims and application for refund of duties and taxes shall be made in writing and filed with the Bureau within 12 months from the date of payment of duties and taxes.
We accept, Mr. President.
Thank you. On requirements to keep records, on
Can
page...
you have the rationale on that? Because
Yes, Mr. President.
You are extending the payment
Yes.
period.
Mr. President, a claim for refund of taxes should also be included in the formal written application filed with the Bureau. A 12-month period instead of 6-month period is recommended pursuant to the revised Kyoto Convention General Annex Standards 4.18 to 4.24 on repayment. Such period is also more practicable as it usually takes owners or importers time to gather relevant documents and accountable forms to support claims for refund to the satisfaction of the Bureau.
Thank you.
Mr. President, if I may continue, Mr.
Please
Sponsor.
proceed.
On requirement to keep records, on page 86, line 5, section 1003, amend paragraph 1 of the provision to read as follows. Section 1003, requirement to keep records. Letter A, all importers are required to keep at their principal place of business in the manner prescribed by regulations to be issued by the Commissioner, and for a period of 10 years from the date of final payment of duties and taxes or customs clearance, as the case may be, all records pertaining to the ordinary course of business and to any activity or information contained in the records required by this title in connection with any such activity.
Sponsor? What does the sponsor say?
Suspend.
Move to suspend for 1 minute, Mr. President.
1 minute suspension.
Ready to resume, Mr. President.
Session is issued.
Well, Mr.
What does
President,
the sponsor say?
10 years might be a bit difficult in lieu of 3 years. Maybe it would be more business friendly to keep the existing 3 years, Mr. President.
Sorry?
It would be more business friendly, I think. Easier for small entrepreneurs, for example. How can they keep records for 10 years? It's difficult.
Yes.
No?
So what is, so do we maintain the present provision?
Mr. President, on that note, I withdraw my, I withdraw the amendment.
I thank the good sponsor of the amendment, Mr. President.
All right.
Next, Mr. President, on failure to pay correct duties and taxes on imported goods, on page 88, line 27, section 1005, amend paragraph 2 of the provision to read as follows. Section 1005, failure to pay correct duties and taxes on imported goods. Letter A, negligence. When a deficiency results from an offender's failure through an act or acts of omission or commission to exercise reasonable care and competence in ensuring that the statement made is correct, the offender shall be charged for committing negligence and, if found guilty, shall be penalized with a fine equivalent to 125% of the revenue loss, provided that, subject to Section 108 of this Act, no penalty shall be imposed on an inadvertent error amounting to simple negligence as defined by rules promulgated by the Secretary of Finance upon recommendation of the Commissioner.
We accept, Mr. President.
The rationale here, Mr. President, is that Standard 3.39 of the revised Kyoto Convention General Annex provides for the non-imposition of penalties on inadvertent errors or simple negligence. And to prevent abuse by importers, inadvertent errors amounting to negligence should be defined according to rules promulgated by the Secretary of Finance upon recommendation of the Commissioner.
Approved.
On appeal to the Commissioner for Protest Cases, Mr. Sponsor, on page 100 after line 29, on section 1126, insert the following paragraph as second paragraph of the provision, amending the same to read as follows. Section 1126, appeal to the Commissioner. In forfeiture cases, the person aggrieved by the decision of a district officer may, within 15 days or 5 days in case of perishable goods, from receipt of the decision, file a written notice of appeal to the district officer with a copy furnished to the Commissioner of his intention to appeal the action or decision for the district officer together with the payment of the required appeal fee. The district officer shall immediately transmit all the records of the proceedings to the Commissioner, who shall review and decide on the appeal within 30 days from receipt of the records, or 15 days in the case of perishable goods, provided that if within 30 days no decision is rendered, the decision for the district officer under appeal shall be deemed affirmed. On appeal filed beyond the period herein prescribed shall be dismissed. Appeals to protest cases shall be governed by Section 114.
We accept, Mr. President.
Lastly, Mr. President, on abandonment, on page 103, after line 2, Section 1129, insert the following penultimate paragraph of the provision, amending the same to read as follows. Section 1129, abandonment, kinds and effects of. E. When the owner or importer fails to claim goods in customs bonded warehouses within the prescribed periods.
We accept, Mr. President.
Any objection? Here and approved.
Mr. President, that's all for myself and what Senator Santiago had requested. We thank the good sponsor and, of course, the Senate President. Thank you very much.
Thank you, gentleman from Tarlac and Senator Santiago, for the amendments. There are no other individual amendments for now, Mr. President, but some senators, specifically Senator Recto, has asked for time to study the measure and propose amendments by next week. So in view of that, I move that we suspend consideration of Senate Bill 2968 under Committee Report 264.
All right. We can calendar this Monday with Senator Recto proposing the individual amendments, if that's enough.
Mr. President, I move that we transfer from the calendar for ordinary business to the calendar for special orders the following. House Bill 5591 under Committee Report number 293, entitled An Act Extending for a Period of 25 Years the term of the franchise granted to Tarlac Electric Incorporated, formerly known as Tarlac Enterprises Incorporated, to construct, operate, and maintain an electric light, heat, and power system in the city of Tarlac, province of Tarlac, provided under Republic Act number 7606. House Bill 6012 under Committee Report 295, entitled An Act Extending for Another 25 Years the Franchise Granted to Bell Telecommunications Philippines Incorporated, amending for the purpose Republic Act 7692, entitled An Act Granting to Bell Telecommunications Philippines Incorporated a franchise to install, operate, and maintain telecommunication systems throughout the Philippines for other purposes. House Bill 4507 under Committee Report 296, entitled An Act Renewing the Franchise of Contel Communications Incorporated, assignee of the grantee under Republic Act number 3932 as amended by Republic Act number 7401, entitled An Act Granting the Concepcion Industries Incorporated a franchise to construct, maintain, and operate radio telephone stations for the transmission and reception of radio communications within the Philippines for another 25 years from the effectivity of this act. House Bill 5592 under Committee Report 297, entitled An Act Renewing the Franchise Granted to Far East Broadcasting Company Philippines Incorporated under Republic Act 8115, entitled An Act Granting the Far East Broadcasting Company Philippines Incorporated a franchise to construct, maintain, and operate non-commercial radio broadcasting stations in the Philippines. House Bill 5982 under Committee Report 298, entitled An Act Renewing for Another 25 Years and expanding to radio television broadcasting national in scope throughout the Philippines the franchise granted to Mabuhay Broadcasting System Incorporated under Republic Act 7395, entitled An Act Granting the Mabuhay Broadcasting System Incorporated a franchise to construct, install, operate, and maintain radio broadcasting stations in the island of Luzon and for other purposes. House Bill 5940 under Committee Report 299, entitled An Act Renewing for Another 25 Years the franchise granted to Progressive Broadcasting Corporation under Republic Act number 7163 as amended by RA 8162. House Bill 5154 under Committee Report 300, entitled An Act Granting the People Broadband and Telecommunications Corporation a franchise to construct, install, establish, operate, and maintain telecommunication systems throughout the Philippines. House Bill 5582 under Committee Report 301, entitled An Act Renewing the Franchise Granted to Radio Veritas Global Broadcasting System Incorporated to construct, install, operate, and maintain for religious, educational, cultural, and commercial purposes radio and television broadcasting stations in the Philippines and for other purposes under Republic Act 7579 to another 25 years. Move to transfer these from the to the calendar for special orders, Mr. President.
Any objection? The franchise bills enumerated by the acting majority leader is transferred from the calendar for ordinary business to the calendar for special orders.
Mr. President, with the consent of the body, I move that we consider on second reading under one omnibus sponsorship speech the House bills enumerated as reported out under their respective committee reports.
Any objection? Hearing none, a sponsorship speech to cover the 8 franchise bills is in order.
Mr. President, with the permission of the body, I move that the Secretary read only the numbers of the said bills without prejudice to inserting into the record the whole text and titles thereof.
Okay. The Secretary is directed to do so.
House Bill number 5591, House Bill number 6012, House Bill number 4507, House Bill number 55992, House Bill number 5982, House Bill number 5940, House Bill number 5154, House Bill number 5582.
Mr. President, I move that we recognize Senator Osmeña to deliver an omnibus sponsorship speech for all the House bills enumerated.
Senator Osmeña is recognized to deliver a sponsorship speech on all the 8 franchise bills now under consideration.
Thank you, Mr. President. Mr. President, distinguished colleagues, I rise to present for the Senate's approval the granting of a franchise to a new player in the telecommunications industry and the renewal of term of 7 existing franchises which are the subject of the following House bills. The new one is House Bill number 5154, covered by Committee Report 300, entitled An Act Granting the People Broadband and Telecommunications Corporation a franchise to construct, install, establish, operate, and maintain telecommunication systems throughout the Philippines, introduced by Representatives Robes, Teodoro, and Agabao. For renewal, House Bill number 5591, covered by Committee Report 293, entitled An Act Extending for a Period of 25 Years the term of the franchise granted to Tarlac Electric, formerly known as Tarlac Electric Enterprises, Inc., to construct, operate, and maintain an electric light, heat, and power system in the city of Tarlac, province of Tarlac, provided under Republic Act 2606, introduced by Congressmen Yap, Teodoro, and Alipin. House Bill number 6012 under Committee Report 295, entitled An Act Extending for Another 25 Years the Franchise Granted to Bell Telecommunications Philippines, Inc., amending for the purpose Republic Act number 7692, entitled An Act Granting to Bell Telecommunications Philippines a franchise to install, operate, maintain telecommunication systems throughout the Philippines and for other purposes, introduced by Representatives Robes, Teodoro, Salvacion, et al. Number 4, House Bill number 4507 under Committee Report 296, entitled An Act Renewing the Franchise of Contel Communications Incorporated, assignee of the grantee of under Republic Act numbered 3932 as amended by Republic Act numbered 7401, entitled An Act Granting the Concepcion Industries Incorporated a franchise to construct, maintain, and operate radio telephone stations for the transmission and reception of radio communications within the Philippines for another 25 years from the effectivity of this act, introduced by Representatives Yolago, Teodoro, and Alipin. Number 5, House Bill number 5592, as covered by Committee Report 297, entitled An Act Renewing the Franchise Granted to Far East Broadcasting Media Company Philippines, Inc., under Republic Act number 8115, entitled An Act Granting the Far East Broadcasting Company Philippines, Inc., a franchise to construct, maintain, and operate non-commercial radio broadcasting stations in the Philippines, introduced by Representatives Cruz Gonzalez and Teodoro. Number 6, House Bill number 5982 under Committee Report number 298, entitled An Act Renewing for Another 25 Years and Expanding to Radio Television Broadcasting, national in scope, throughout the Philippines, a franchise granted to Mabuhay Broadcasting System, Inc., under Republic Act 7935, entitled An Act Granting the Mabuhay Broadcasting Systems, Inc., a franchise to construct, install, operate, and maintain radio broadcasting stations in the island of Luzon and for other purposes, introduced by Representatives De Venecia, Primicias, Agabas, Tambunting, et al. Number 7, House Bill number 5940, as covered by Committee Report 299, entitled An Act Renewing for Another 25 Years the franchise granted to Progressive Broadcasting Corporation under Republic Act 7163 as amended by Republic Act 8162, introduced by Representatives Tupas, Lagdameo M., Lagdameo A, et al. And number 8, House Bill number 5582 under Committee Report 301, entitled An Act Renewing the Franchise Granted to Radio Veritas Global Broadcasting System, Incorporated, to construct, install, operate, maintain for religious, educational, cultural, and commercial purposes radio and television broadcasting stations in the Philippines and for other purposes under Republic Act numbers 7500 and 79 to another 25 years, introduced by Representatives Reyes, Teodoro, Robes, et al. Mr. President, the Committee on Public Services of the Senate recommends the approval of these measures for the following reasons. First, all applicants have complied with the ownership and management requirements under Section 11 of Article 12 of the 1987 Constitution, which mandates that franchises for the operation of a public utility must be granted only to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines whose capital is at least 60% owned by citizens of the Philippines. As discussed in the 2012 Supreme Court decision in the case of Heirs of Gamboa versus Secretary of Finance, the driving force behind this constitutional provision was the so-called economic patriotism by the framers of our Constitution, which limited foreign equity in partially nationalized industries to grant effective control to Filipinos. Second, the regulatory agencies such as the Securities and Exchange Commission, the National Telecommunications Commission, and the Energy Regulatory Commission expressed their support to the passage of these measures, which grant a 25-year term to each applicant. This, of course, subject to amendment, alteration, or repeal by Congress when the common good so requires. Third, the committee has examined and evaluated the pertinent documentary requirements submitted by the applicants as to their audited financial statements, permits to operate, latest general information sheet, and company profiles, and found them to have complied with the requirements prescribed by the relevant laws, rules, and regulations. Finally, the continued operation of the applicants would encourage competition in the market pursuant to the policy of the government to prohibit or regulate monopolies. Thus, the approval of the aforementioned House bills as amended by the Senate is earnestly sought. Thank you, Mr. President.
Thank you, Senator Osmeña. Majority Leader.
Mr. President, I move that we suspend consideration of the measures under consideration.
Any objection? Hearing none, so suspended.
Mr. President, regarding the Customs Modernization or Senate Bill 2968, may we ask for a clean copy for the next, for purposes
Yes,
of...
the Secretariat is, the Secretary is directed to produce clean copies of the measure and indicating therein the amendments introduced at today's session, and this will be the basis of the amendments that will be proposed on Monday.
Mr. President, may I ask for a few minutes suspension?
1 minute suspension.
They're making the...
Session is resumed. Majority Leader.
Mr. President, I move that we transfer from the calendar for ordinary business to the calendar for special orders the following: House Bill 103 under Committee Report 269, House Bill 3945 under Committee Report 270, House Bill 3962 under Committee Report 271, House Bill 3964 under Committee Report 272, House Bill 3968 under Committee Report 273, House Bill 3969 under Committee Report 274, House Bill 3973 under Committee Report 275, House Bill 4565 under Committee Report 276, House Bill 4646 under Committee Report 277, House Bill 4797 under Committee Report 278, House Bill 4798 under Committee Report 279, House Bill 4799 under Committee Report 280, House Bill 5552 under Committee Report 281. So move.
There is a motion to transfer the enumerated House bills to the calendar for special orders. Is there any objection? Hearing none, motion is carried.
Mr. President, with the consent of the body, I move that we consider on second reading under one omnibus sponsorship speech the House bills enumerated as reported out under the respective committee reports.
Any objection? There being none, there be an omnibus sponsorship speech for all the House bills enumerated by the Majority Leader.
With the permission of the body, I move that the Secretary read only the titles of the proposed bills without prejudice to inserting into the record the whole texts thereof.
The Secretary will read the titles of the measures under consideration.
House Bill number 103, an act declaring June 23 of every year as a special working holiday and no class day in schools in the city of Bacoor
Okay, so
to commemorate its anniversary as a city.
What?
House Bill number 3945, an act declaring July 4 of every year a special non-working holiday in the province of Lanao del Sur and commemoration of his foundation day. House Bill number 3962, an act declaring April 16 of every year a special non-working holiday in the city of Marikina and commemoration of its founding anniversary as Marikina City Day.
House Bill number 3964, an act declaring March 9 of every year special non-working holiday in the province of Abra in commemoration of its foundation anniversary and the culmination of the Brinian Kawayan Festival. House Bill number 3968, an act declaring June 21 of every year special non-working holiday in Tagaytay City, province of Cavite, in commemoration of its foundation day to be known as Charter Day of Tagaytay City or Araw ng Lungsod ng Tagaytay. House Bill number 3969, an act declaring June 30 of every year special non-working holiday in the city of Imus, province of Cavite, in commemoration of its founding anniversary. House Bill number 3973, an act declaring September 29 of every year a special non-working holiday in the city of Bacoor, province of Cavite, in commemoration of the Araw ng Bacoor. House Bill number 4565, an act declaring May 8 of every year as Hermosa Day, and special non-working public holiday in the municipality of Hermosa, province of Bataan. House Bill number 4646, an act declaring 29 of every year special non-working holiday in the municipality of Lian, province of Iloilo, in honor of Captain Jose Calugas Sr. to be known as Jose Calugas Day. House Bill number 4797, an act declaring October 31 of every year special non-working holiday in the municipality of Porac, province of Pampanga, in commemoration of its founding anniversary to be known as Porac Day. House Bill number 4798, an act declaring August 11 of every year special non-working holiday in the city of Ilagan, province of Isabela, in commemoration of its started anniversary to be known as Ilagan City Charter Day. House Bill number 5552, an act declaring February 13 of every year special non-working holiday in the city of Parañaque, Metro Manila, in commemoration of its foundation anniversary.
Majority Leader.
Mr. President, I move that we recognize Senator Marcos to deliver an omnibus sponsorship speech for all the House bills enumerated.
Senator Marcos is recognized to deliver the omnibus sponsorship speech on these bills under consideration.
Thank you, Mr. President. Mr. President, distinguished colleagues, today it is my honor as chairman of the Committee on Local Government to sponsor the following committee reports on special working holiday bills. Number 1, Committee Report number 269 containing House Bill number 103, authored by Representatives Mercado Revilla and Primicias Agabas, which seeks to declare June 23 of every year a special working holiday and no-class day in schools in the city of Bacoor to commemorate its anniversary as a city. Number 2, Committee Report number 270, with House Bill number 3945, authored by Representatives Adyong, Huaminal, Hernandez, Bello S., Gutierrez, Santiago, and Primicias Agabas, which proposes to declare July 4th of every year a special non-working holiday and no school day in schools in the province of Lanao del Sur to commemorate its foundation day. Number 3, Committee Report number 271, containing House Bill number 3962, authored by Representatives Chodoro and Primicias Agabas, which declares April 16 of every year a special working holiday and no-class day in schools in the city of Marikina in commemoration of its founding anniversary as a city. Number 4, Committee Report number 272 on House Bill number 3964, authored by Bernos and Primicias Agabas, which declares March 9th of every year a special working holiday and no-class day in schools in the province of Abra in commemoration of its foundation anniversary and the culmination of the Abreñan Kawayan Festival. Number 5, House Bill number 3968 under Committee Report number 273, authored by Representatives Tolentino and Primicias Agabas, seeks to declare June 21 of every year a special working holiday and no-class day in schools in the city of Tagaytay, province of Cavite, in commemoration of its foundation day. Number 6, Committee Report number 274 containing House Bill number 3969, authored by Representatives Advincula and Primicias Agabas, which declares June 30th of every year a special working holiday and no-class day in schools in the city of Imus, province of Cavite, in commemoration of its founding anniversary. Number 7, Committee Report number 275, with House Bill number 3974, with House Bill number 3973, authored by Representatives Mercado Revilla and Primicias Agabas, which declares September 29 of every year a special working holiday and no-class day in schools in the city of Bacoor, province of Cavite, in commemoration of the Araw ng Bacoor. Number 8, Committee Report number 276 containing Senate Bill number 2647, authored by Senator Villar, and House Bill number 4565, filed by Representatives Roman, Primicias Agabas, and Garcia G., which declare May 8 of every year as Hermosa Day and a special working holiday and no-class day in schools in the municipality of Hermosa, province of Bataan. Number 9, Committee Report number 277 on House Bill on number 4646, authored by Representatives Goriseta, Tupas, Garin O, Treñas, Biros, Defensor, and Primicias Agabas, which declares December 29 of every year a special working holiday and no-class day in schools in the municipality of Leon, province of Iloilo, in honor of Captain Jose Calugas Sr., to be known as Jose Calugas Day. Number 10, Committee Report number 278, containing Senate Bill number 2386, filed by Senator Manuel Lapid, and House Bill number 4797, authored by Representatives Macapagal Arroyo and Primicias Agabas, which declare October 31 of every year a special working holiday and no-class day in schools in the municipality of Porac, province of Pampanga, in commemoration of its founding anniversary. Number 11, House Bill number 4799 under Committee Report number 280, authored by Representatives Tejada, Acharon, Sakaluran, Sakdalan, Mendoza R., Pacquiao, Sema, Primicias Agabas, and Hernandez, which declares September 1 of every year a special working holiday and no-class day in schools in the province of North Cotabato in commemoration of its founding anniversary. Number 12, Committee Report number 281, containing House Bill number 5552, authored by Olivares and Primicias Agabas, which declares February 13th of every year a special working holiday and no-class day in schools in the city of Parañaque in commemoration of its foundation day. And number 13, Committee Report number 279, on House Bill number 4798, authored by Representatives Bello S. and Primicias Agabas, which declares August 11 of every year a special working holiday in the city of Ilagan, province of Isabela, in commemoration of its Charter Day anniversary, to be known as Ilagan City Charter Day. It is important to emphasize that these House bills were originally filed as special non-working holidays. However, the Department of Labor and Employment has registered reservations to the declaration of special non-working holidays in commemorating historical events in provinces, cities, and municipalities because, according to DOLE, in its letter to this representation dated on 10 June 2015, additional non-working holidays each year would mean a day's wage loss to our salaried earners. DOLE instead proposes the option of commemorating significant historical events, whether national or local, as special working holidays to promote productivity and competitiveness. During the committee hearing held last 10 June 2015, the authors of the House bills have unanimously agreed to amend their measures to special working holidays. In view of the foregoing, this representation respectfully requests this august chamber to approve committee reports numbers 269, 270, 271, 272, 273, 274, 275, 276, 277, 278, 279, 280, and 281. Thank you, Mr. President.
Thank you, Senator Marcos. With the permission of the chamber, 1 minute suspension.
Yeah. Two seven nine.
Sunny, can we proceed? Session is resumed. Majority Leader.
Mr. President, I'm with the permission of the body, since we move that we close the period. There are no members who wish to interpolate on the enumerated local bills. I thus move that we close the period of interpolations on all the bills.
Any objection? There being none, period for interpolation on the bills are hereby terminated.
Mr. President, again with the permission of the body, since the local bills are subject to common committee amendments, I move that we take them up in toto again, with the exception of House Bill 4798 under Committee Report 279, which has an amendment peculiar to that bill.
All right. So we
Move to open the period of committee amendments on an omnibus motion to propose committee amendments on the said bills, except for House Bill 4798, Mr. President.
under Committee Report 279.
Yes.
Any objection? Hearing none, approved. The sponsor is once more recognized.
We can,
Omnibus.
Very well, thank you, Mr. President. I would like to propose an omnibus committee amendment to all the bills that have been sponsored today, except for House Bill number 4798 with Committee Report 279. The omnibus committee amendments that I would like to propose are these. On page 1, line 2, delete the word non-working and in lieu thereof insert the word working.
Any
So moved, Mr.
objection? In all the bills under consideration, in all the bills under consideration, page 1, line 2, the word non-working is hereby deleted, and in lieu thereof, the word working is inserted. Any objection? Hearing none.
On the same page and line, after the word holiday, insert the phrase, and no class day in schools. So moved, Mr. President.
Any objection? Hearing none. Approved.
On the same page, line 3, after the word day, insert a new section to read as follows. Section 2, for work performed on a special working holiday, an employee is entitled to his or her regular wage, and renumber the succeeding sections accordingly. So
Any
moved,
objection? Hearing none. Approved.
The title of the bill should now read as follows.
One minute suspension.
1 minute suspension, please. Ano yun? What? That's all? Okay.
No? Hindi. Pwede yan. Pwede naman yan eh.
Okay. Ready to resume, Mr. President.
Set, ready to resume.
On the title of the said bills, the word working holiday, the word non-working will be deleted, and in lieu thereof, the word working will replace it.
All right. An omnibus amendment to all the titles. Whenever the word non-working is found, the same is hereby deleted, and the word working is the amendment. Any objection? Hearing none. Approved.
Mr. President, may I proceed with the committee amendments on House Bill 4798 with Committee Report 279?
Before that, Mr. Sponsor, the phrase "and no class day" should be inserted in the title.
What we have is an aggregate special work and no school day in schools. That is what we already have in the titles.
All right. Okay.
Therefore, the omnibus amendment will only be from non-working to working in the titles of the said.
There are just to be safe.
Yes.
There are certain bills that does not have the phrase "no class day." I would suggest that after the holiday in all the titles of the bills, Mr. Sponsor, after holiday we insert the phrase "and no class day in schools.
Very well, sir. We will amend that. We will amend that amendment to now read after the word holiday in the titles to read "and no school day in schools." Or no class day. We have here
And no class day.
no class days is the more proper term. Very well, sir.
And
No class day in schools.
All right. So the omnibus amendment would be to insert "and no class day in schools" in between holiday and "in" as
And
it
in.
appears in every title of the bills under consideration. Any objection? Hearing none, approved.
Mr. President, before the good sponsor moves for the amendments on House Bill 4798, may we move to close the period of committee amendments on the all the bills under consideration.
Period. Any objection? Hearing none. Period for committee amendments terminated.
There are no individual amendments, I believe, Mr. President, as well. If we may close the period of individual amendments on all the bills, with the
So-
exception of 4798.
So terminated.
If we may approve on second reading, all the local bills, House Bill 103, 3945, 3962, 3964, 3968, 3969, 3973, 4565, 4646, 4797, 4799, and 5552 under the aforesaid committee reports. I so move, Mr. President.
The chair would prefer that we read it one by one. For the record, the approval should be per bill. If
Okay. We thus move to approve House Bill number 103 under Committee Report 269. So move
on second reading.
on second reading. We thus move to approve House Bill 3945 under Committee Report 270. So move.
Approved.
3962 under Committee Report 271. So move. 3964 under Committee Report 272.
Approved.
3968 under Committee Report 273. So move.
Approved.
3969 under Committee Report 274. So move.
Approved.
3973 under Committee Report 275.
Approved on second reading.
4565 under Committee Report 276 to be approved on second reading. So move.
Approved.
House Bill 4646 under Committee Report 277 to be approved on second reading. I so move.
Approved.
House Bill 4797 to be approved on second reading under Committee Report 278. So move.
Approved.
House Bill 4799 under Committee Report 280 approved on second reading. So move.
Approved.
House Bill 5552 under Committee Report 281 to be approved on second reading. I so move, Mr. President.
Approved.
I move that we suspend consideration of the said House bills.
Consideration is suspended.
Mr. President, if we may resume consideration of House Bill 4798 under Committee Report 279 and recognize once more the sponsor, Senator Marcos.
In order.
Thank you, Mr. President. May we propose this committee amendments on House Bill 4798. On page 1, line 1, delete the word non-working, and in lieu thereof, insert the word working. So move, Mr. President.
Any objection? Hearing none.
On the title of the bill, delete the word non-working, and in lieu thereof, insert the word working. So move, Mr. President.
Approved.
Those are all the committee amendments for Bill 4798.
All right. Majority Leader.
Mr. President, I move that we close the period of committee amendments on House Bill 4798.
Any objection or none? Approved.
I believe there are no individual amendments, Mr. President. I move that we close likewise the period of individual amendments.
Closed.
I move that we approve on second reading House Bill 4798 under Committee Report 279.
Any objection? Hearing none. Approved. Thank you, Senator Marcos. Thank you, Majority Leader.
Mr. President,
There's an additional reference of business.
I move for the additional reference of business, Mr. President.
The Secretary will read the additional reference of business.
Additional reference of business, bill on first reading, Senate number 3031, entitled An Act Amending Pertinent Laws on the Retirement Benefits and Pension of the Uniformed Personnel of the Uniformed Services and providing funds therefore, introduced by Senator Trillanes IV.
To the Committee on National Defense, Security, Government Corporations, and Public Enterprises. 1 minute suspension.
Ready to resume, Mr. President.
Session is resumed.
Mr. President, there being no other business to take up today, I move that we adjourn the session until 3 o'clock of the afternoon of Monday, December 14, 2015. So moved.
Before we act on the motion, for the record, I was informed earlier that the bicameral conference committee report on the disagreeing provisions on the General Appropriations Act for 2016 is being routed, so there is no committee report having been filed yet. There is no bicameral conference committee report having been filed yet, so we take that up on Monday.
Yes, Mr. President.
There's a motion that we adjourn until December 14, Monday at 3 o'clock in the afternoon. Any objection, hearing none, session adjourned until 3 p.m. of December 14, 2016.